All rise. Veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. La Giant Tribunal Penal International pour l'ex-Yougoslavie est ouvert. Please be seated.
Good morning to everyone in and around this courtroom. Mr. Registrar, would you please call the case?
Good morning, Your Honours. I call case number IT 0992T, the prosecutor versus Ratko Mladić.
Thank you, Mr. Registrar. Mr. Ivicic, it was announced that you would like to address the court.
That's correct, Your Honours. With Your Honours' leave, Mr. Lead Counsel Branko Lukic and I ask leave to read into the record our notice of exception to proceedings, which was filed last night.
Mr. Ivicic,
Yes.
the notice of exception has been filed, has been distributed. It is a public filing, so everyone can take notice of what you brought to the attention of this court. We have considered the content of it, and the chamber finds that there's no need to repeat that.
As long as we have on the record that Your Honours have read it, that's all I
Yes, we have it, we have received it, and it's a public filing.
Thank you very much, Your Honour.
Thank you, Mr. Ivicic. Before we continue, and it was not even on the record, Mr. Ivicic, that you were there, because I'd like to put on the records the appearances I see for the prosecution: Mr. McCloskey, Mr. Tiger, Mr. Weber, Ms. Hassan, Mr. Traldi, and of course supported by your support team. I see for the defense Mr. Lukic, I see Mr. Ivicic, I see Mr. Stojanovic, and I see Mr. Saljan is there as well, also supported by your support team. We are sitting today to deliver the Chamber's judgment in this case. The Chamber stresses that during this hearing it will only deliver a summary of its findings. This summary does not in any way form part of the judgment. The only authoritative account of the Chamber's findings is in the written judgment, which will be made available after this hearing. The accused, Ratko Mladić, was indicted on the 24th of July and the 16th of November 1995. He was arrested in Serbia on the 26th of May 2011, almost 16 years after the initial indictments. His trial began on the 16th of May 2012, and the hearing of evidence lasted for over 4 years. Between the 5th and the 15th of December 2016, the parties presented their closing arguments. The Chamber set for 530 trial days, during which it received the evidence of 592 witnesses and nearly 10,000 exhibits. The Chamber also took judicial notice of approximately 2,000 adjudicated facts. The accused stood trial for 11 counts of crimes allegedly committed in his capacity as the commander of the main staff of the Army of the Bosnian Serb Republic, also known as the VRS, between the 12th of May 1992 and 30th November 1995. The indictment charged 2 counts of genocide and 5 counts of crimes against humanity, namely prosecution, murder, extermination, deportation, and the inhumane act of forcible transfer. It also charged 4 counts of violations of the laws or customs of war, namely murder, acts of violence the primary purpose of which was to spread terror among the civilian population, unlawful attacks on civilians, and the taking of hostages. The geographical scope of the indictment included Sarajevo, Srebrenica, and 15 municipalities in Bosnia and Herzegovina. The prosecution alleged that the accused participated in 4 joint criminal enterprises, also known as JCEs, which I'll now summarize. First, an overarching JCE, which had the objective of permanently removing Muslims and Croats from Serb-claimed territory in Bosnia and Herzegovina through the commissions of the crimes charged in the indictment, including genocide, persecutions, extermination, murder, the inhumane act of forcible transfer, and deportation. Second, a Sarajevo JCE, which had the objective of spreading terror among the civilian population through a campaign of sniping and shelling as charged in the indictment, including through murder, acts of violence, the primary purpose of which is to spread terror among the civilian population, and unlawful attacks on civilians. Third, a Srebrenica JCE, the objective of which was the elimination of Bosnian Muslims in Srebrenica through the crimes charged in the indictment, including genocide, persecutions, extermination, murder, the inhumane act of forcible transfer, and deportation. Fourth, a hostage-taking JCE, the objective of which was taking UN personnel hostage to prevent NATO from conducting airstrikes against Bosnian Serb military targets through the crime of taking of hostages as a war crime. In addition, the prosecution charged the accused with having planned, instigated, ordered, and/or aided and abetted the crimes in the indictment. Finally, it also charged the accused as a superior pursuant to Article 7(3) of the statute. The Chamber will now briefly summarize its findings. The Chamber will begin by addressing its factual and legal findings with regard to the crime base in each component of the case, and then turn to its findings concerning the responsibility of the accused. The Chamber found that there was an armed conflict in the territory of Bosnia and Herzegovina throughout the period relevant to the indictment, as required pursuant to Article 3 of the statute. The Chamber will now address the municipalities component of the case. The Chamber found that in several of the municipalities, murders were committed which constituted crimes against humanity and violations of the laws and customs of war. The Chamber found that before, during, and after Bosnian Serb forces attacked non-Serb villages, many victims were killed. Circumstances were brutal. Those who tried to defend their homes were met with ruthless force. Mass executions occurred, and some victims succumbed after being beaten. Many of the perpetrators who had captured Bosnian Muslims showed little or no respect for human life or dignity. For example, on or about the 31st of May 1992, Bosnian Serb forces rounded a group of Bosnian Muslims men near the Vrpolje bridge in Sanski Most municipality. 4 of them were killed on the way to the bridge. Once at the bridge, the Bosnian Muslims were forced to jump into the river one by one. Once in the water, Bosnian Serb forces opened fire, killing at least 28 of the Bosnian Muslims, all male, including a minor and 2 elderly men. 1 man survived. In July 1992, 24 Bosnian Muslim detainees suffocated while being transported from Betonirka detention center to Mladić camp. Guards at Betonirka confiscated water bottles and forced some detainees to consume salt before the 9-hour journey. The trucks were hot, crammed, covered with tarpaulins, and the detainees received no water. In an attempt to survive, a number of them drank their own urine and made holes in the tarpaulins to get air, but stopped when the policemen escorting the men threatened them. Once they arrived at Mladić camp, those deemed not healthy were put back on the truck, as Božidar Popović, the camp commander, said, and I quote, "Put the shit back. I don't need dead people." End of quote. The chamber found that some of these murders amounted to exterminations as a crime against humanity. For example, on or around the 25th of July 1992, police and members of the VRS aimed a machine gun at the entrance of room 3 in Kuritem camp, where a large number of detainees were held. During the night, some form of chemical gas was thrown into the room, causing the detainees to panic and for some of them to try to exit. Spotlights were shown on the room, and the soldiers and guards executed the detainees with automatic weapons as they exited, killing many of them. They then proceeded to shoot detainees inside the room, including some who were trying to hide. The soldiers and guards killed between 190 and 220 detainees that night. The chamber found that forcible transfer and deportation were committed in many municipalities. With regard to the conditions at the relevant times, the chamber found, for example, that from the 12th of May 1992 onwards, local authorities in Kotovaros municipality imposed restrictions on Bosnian Muslims and Bosnian Croats' freedom of movement, which were implemented by the VRS. Killings, unlawful detentions, and acts of inhumane treatment were also committed in the municipality in June and July 1992. The chamber found that parts of the Bosnian Muslim and Bosnian Croat population, including women and children, were forcibly displaced from Kotovaros municipality between June and November 1992. The chamber found that deportation and the inhumane act of forcible transfer as a crime against humanity were committed in the municipalities of Banja Luka, Bijeljina, Foča, Ilica, Cluj, Kotovaros, Novigrad, Pale, Prijedor, Rogatica, Sanski Most, Sokolac, and Vlasenica. Turning now to the charge of persecution, the Chamber found, inter alia, that many victims were subjected to unlawful detention and cruel and inhumane treatment on the basis of political, racial, or religious grounds. For example, in several detention camps, conditions were appalling. Food and water were scarce, which led to some cases of severe malnutrition and death. Sanitation facilities were wholly inadequate. Detainees were often allowed to use bathroom facilities only once a day, and there was no consideration for hygiene or preventing the spread of diseases. Detainees were regularly beaten, sometimes with implements such as brass knuckles and iron bars. Medical care was also inadequate. Detainees were forced to rape and engage in other degrading sexual acts with one another. Many Bosnian Muslim women who were unlawfully detained were raped. For example, at a house known as Karaman's House in Foča municipality, several groups of women and girls as young as 12 years old were routinely and brutally raped. The victims would sometimes be assigned to individual soldiers, and other times were forced to have sex with multiple men. One witness gave evidence that a soldier had taken her to a celebration where they were approached by the accused, who asked the soldier whether the witness was his, and I quote, Herzegovinian woman, end of quote, before turning to the witness directly and asking her whether she was, and I quote again, faring better than in Alia's state, end of quote. The Chamber now turns to count 1, genocide in 6 of the municipalities. Genocide encompasses the commission of prohibited acts with the intent to destroy, in whole or in part, a protected group as such. These prohibited acts can include killing or causing serious bodily or mental harm. In this case, the protected groups were Bosnian Muslims and Bosnian Croats. The Chamber found that a large number of Bosnian Muslims and Bosnian Croats in some of these municipalities were subjected to killings and or serious bodily or mental harm. The Chamber then examined the specific intent of the physical perpetrators. The Chamber found by majority, territory dissenting, that the physical perpetrators in Sanski Most, Vlasenica and Foča, and certain perpetrators in Kotovaroš and Prijedor municipalities intended to destroy the Bosnian Muslims in those municipalities as a part of the protected group. The Chamber then considered whether the targeted part constituted a substantial part of the protected group and concluded that the Bosnian Muslims targeted in each municipality formed a relatively small part of the protected group and were also in other ways not a substantial part. Consequently, the Chamber was not satisfied that the only reasonable inference was that the physical perpetrators possessed the required intent to destroy a substantial part of the protected group of Bosnian Muslims. The Chamber will now address the Sarajevo component of the case. From mid-May 1992 until November 1995, the VRS, in particular the Sarajevo Romania Corps, also known as the SRK, deliberately shelled and sniped the civilian population of Sarajevo, often at locations that had little or no military value. As a result, hundreds of civilians were killed and thousands were injured. Many were shot while undertaking daily activities such as walking with their children, fetching water, collecting wood, or while at the market. For example, on 18 November 1994, a member of the SRK shot a Bosnian Muslim woman walking on the street with her children. The bullet passed through her abdomen and hit her 7-year-old son in the head, killing him. On 5 February 1994, members of the Sarajevo Romania Corps shelled Makale Market, resulting in the killing of 68 people and injuring over 140. Almost all of the victims were civilians and included women, children, and elderly. In 1994 and 1995, the Sarajevo Romania Corps attacked Sarajevo with modified air bombs, highly inaccurate weapons that had a devastating effect on impact. Consequently, the Chamber found that the use of modified air bombs constituted indiscriminate attacks on individual civilians and the civilian population as a whole. The Chamber, having considered the nature, manner, timing, location, and duration of these sniping and shelling attacks, found that it was the intention of the perpetrators, all members of the Sarajevo Romania Corps, to target civilians and to shell the city in an indiscriminate manner. The hardships the people of Sarajevo suffered were considerable. They routinely lacked basic necessities such as food, water, gas, and electricity. They were made to live in a state of constant distress. Every time they or their loved ones left their homes, they wondered if they would be targeted by sniper or artillery fire. Taking all of this into consideration, the Chamber found that the members of the SRK intended to spread terror among the population of Sarajevo, and that the infliction of terror was the primary purpose of sniping and shelling. The Chamber found that members of the SRK committed murder, unlawful attacks on civilians, and terror as violations of the laws or customs of war, and murder as a crime against humanity. The Chamber will now turn to the Srebrenica component of the case. On the 8th of March 1995, Radovan Karadzic issued Directive Number 7 and ordered the Drina Corps to, and I quote, create an unbearable situation of total insecurity with no hope of further survival or life for the inhabitants of Srebrenica. End of quote. On the 31st of March 1995, Mladić signed Directive Number 7.1, which translated Directive 7 into operational military tasks and called for a strategic operation against the enclave. Approximately 15 to 20 days before the takeover of Srebrenica town, the VRS formed a plan called Krivaja 95 to attack the enclave, intending to make it disappear, to empty it, and to make the area Serbian territory by forcibly removing the Bosnian Muslim population. The VRS attack began on the 6th of July, and by the 11th of July they had entered Srebrenica town. During the attack, the VRS embarked upon a campaign of burning Bosnian Muslim houses and mosques. Thousands of Bosnian Muslims, mostly women, children and elderly, fled to Potocari to seek shelter in the compound used by the UN Protection Force, known as UNPROFOR. The vast majority of the able-bodied Bosnian Muslim men fled the enclave on foot in an attempt to reach Tuzla. By the 12th of July 1995, between 25,000 and 30,000 Bosnian Muslim civilians had gathered in Potocari, 5% of whom were able-bodied men. Conditions in and around the UNPROFOR compound were dire. Food and water were scarce, and there was a shortage of medical supplies. People were exhausted and frightened. Serb forces created a terrifying atmosphere by shelling near the compound and by taking people away, some of whom never returned. From 11 to 12 July 1995, 3 meetings took place at Hotel Fontana in Bratunac between the VRS, UNPROFOR Dutchbat officers, and individuals selected to represent the Bosnian Muslims to discuss what was described as the evacuation of the civilian population in Potocari. The VRS's screening of men aged between 16 and 60 for war crimes was also discussed. On the 17th of July 1995, a document was signed stating that the civilians were to be, and I quote, evacuated, end of quote, to Kladanj municipality by the VRS and Bosnian Serb Republic police forces under the supervision and escort of UNPROFOR. From the 12th to the 14th of July 1995, the VRS and the Ministry of the Interior, known as the MUP, organized the transport of approximately 25,000 Bosnian Muslims, mostly women, children and elderly, out of Srebrenica enclave to territory under control of the Army of Bosnia and Herzegovina in convoys of buses and trucks. Bosnian Serb soldiers systematically separated Bosnian Muslim men of military age who were trying to get on board. Some of the separated males were as young as 12 years old and some older than 60 years. The separations were frequently aggressive. The people being transferred were told that the Bosnian Muslim men would follow later. They never followed. The Bosnian Muslim men taken from Potocari were detained in temporary detention facilities and later, together with others captured from the column fleeing on foot, bused to various execution sites in Srebrenica, Bratunac and Zvornik municipalities. The chamber found that many of these men and boys were cursed, insulted, threatened, forced to sing Serb songs, and beaten while awaiting their execution. Bosnian Serb forces, primarily members of the VRS, systematically murdered several thousand Bosnian Muslim men and boys, the vast majority of over just a few days from the 12th until the 17th of July 1995. The Chamber will now describe some specific examples. On 13 and 14 July 1995, approximately 1,000 unarmed Bosnian Muslim males, including children and elderly, were executed in Kravica warehouse. On 16 July 1995, between 1,000 and 1,200 Bosnian Muslim civilians at the Branjevo military farm were summarily executed. Prior to the execution, some of them had their hands tied, were blindfolded, and forced to pray in, and I quote, the Muslim manner, end of quote. On the very same day, approximately 500 Bosnian Muslim men and 2 women were executed inside Pilica Cultural Center. During several weeks in September and early October 1995, senior members of the VRS and the MUP attempted to conceal their crimes by exhuming their victims' remains from several mass graves, and then reburying those remains in more remote areas in Zvornik and Bratunac municipalities. Their attempt to cover up the Srebrenica massacres ultimately failed. The Chamber found that Bosnian Serb forces engaged in an operation to murder thousands of Bosnian Muslims from Srebrenica with discriminatory intent so as to constitute the crime of persecution. Some of those murder incidents were found to constitute extermination. The Chamber also found that several of the charged incidents constituted the inhumane act of forcible transfer. The Chamber now turns to the allegation of genocide in Srebrenica. Count 2 of the indictment. The Chamber found that the prohibited acts as set out in the legal definition of genocide, that is, killing and causing serious bodily and mental harm, were committed by the physical perpetrators against the Bosnian Muslims of Srebrenica. The Chamber then examined the specific intent of the physical perpetrators. As explained in detail in the judgment, the Chamber found that the physical perpetrators intended to destroy the Bosnian Muslims in Srebrenica, a substantial part of the protected group. The Chamber therefore found that the crimes of genocide, persecution, extermination, murder, and the inhumane act of forcible transfer were committed against Bosnian Muslims in and around Srebrenica. The Chamber now turns to the hostage component of the case. Between the 25th of May and the 24th of June 1995, VRS soldiers and officers, including members of the military police and Bosnian Serb police officers, arrested and detained between 260 and 400 UN military observers, known as UNMOs, and UNPROFOR personnel, all in Bosnia and Herzegovina. The UNMOs arrested by police officers were placed in VRS custody. Some were tied with chains or handcuffs, at times at gunpoint, outside locations of strategic and military importance, while others were told they would be killed if NATO were to launch further airstrikes. Some of the UN personnel were filmed. threats were also directly communicated to UN officials. The UN personnel were detained in order to, inter alia, exert leverage over NATO to stop airstrikes. Between the 2nd and the 24th of June 1995, the VRS, and in particular the accused, ordered the release of UN personnel pursuant to an order from Karadzic. The perpetrators knew that UNMO and UNPROFOR personnel were taking no active part in the hostilities when captured and placed in detention, and that they were entitled to the protection of Common Article 3 of the Geneva Conventions. The Chamber found that these acts constituted the crime of hostage-taking, a violation of the laws or customs of war, punishable under Article 3 of the statute. The Chamber will now turn to the responsibility of the accused in relation to each alleged joint criminal enterprise. The Chamber found that the accused held various positions in the Yugoslav People's Army and, as of the 12th of May 1992, served as the commander of the main staff of the army of the Bosnian Serb Republic, the VRS, who remained in this position until at least the 8th of November 1996. With respect to the overarching joint criminal enterprise, the Chamber found that between 1991 and the 30th of November 1995, there existed a JCE with the objective of permanently removing Muslims and Croats from Serb-claimed territory in Bosnia and Herzegovina through persecution, extermination, murder, the inhumane act of forcible transfer, and deportation. Having assessed, inter alia, the statements, speeches, and conduct of the accused and the Bosnian Serb leadership, and the acts committed by the physical perpetrators, the Chamber found that the evidence did not support a finding that the crime of genocide formed part of the objective of the overarching JCE. The members of the overarching joint criminal enterprise included Radovan Karadzic, Momcilo Krajisnik, Biljana Plavšić, Nikola Koljević, Bogdan Subotic, Momcilo Mandić, and Micho Stanisic. Many of the charged crimes were committed by units used as tools in furtherance of the overarching joint criminal enterprise. These included members of the VRS, MUP, and territorial defense under the supervision of the Bosnian Serb Ministry of Defense, various paramilitary groups, and members of regional and municipal authorities. The Chamber now turns to the accused's responsibility for the crimes which were found to have been committed in the municipality's component of the case. To determine the accused's contribution, the Chamber considered the accused's acts during the existence of the overarching JCE, in particular, the accused's acts vis-à-vis the VRS, given that many of the principal perpetrators of crimes were VRS members. Between May 1992 and 1995, the accused issued orders which established and organized the VRS and its organs. The accused was also closely involved in VRS operations, as evidenced by regular briefings with Mr. Ivetić.
Your Honors, I've been asked by the accused if he may use the facilities, the bathroom.
Yes. Then I'll first finish my sentence, and then we'll take a break of 5 minutes. I think I started my sentence by saying the accused was also closely involved in VRS operations as evidenced by regular briefings, meetings and inspections, and issued orders and operational directives to VRS units as well as other groups. We'll take a short break and we'll resume at 11:15.
All rise. Voyez-vous lever.